The Factories Act 1948, Act No. 63 of 1948, Chapter 6, Working Hours of Adults. 51. Weekly Hours. No adult worker shall be required or allowed to work in a factory for more than 48 hours in any week. 52. Weekly Holidays. 1. No adult worker shall be required or allowed to work in a factory on the first day of the week, hereinafter referred to as the said day, unless a. He has or will have a holiday for a whole day on one of the 3 days immediately before or after the said day, and b. The manager of the factory has, before the said day or the substituted day under clause a, whichever is earlier, I. Delivered a notice at the office of the inspector of his intention to require the worker to work on the said day and of the day which is to be substituted, and e. Displayed a notice to that effect in the factory, provided that no substitution shall be made which will result in any worker working for more than 10 days consecutively without a holiday for a whole day. 2. Notices given under subsection 1 may be cancelled by a notice delivered at the office of the inspector and a notice displayed in the factory not later than the day before the said day or the holiday to be cancelled, whichever is earlier. 3. Where, in accordance with the provisions of subsection 1, any worker works on the said day and has had a holiday on one of the 3 days immediately before it, that said day shall, for the purpose of calculating his weekly hours of work, be included in the preceding week. 53. Compensatory Holidays. 1. Where, as a result of the passing of an order or the making of a rule under the provisions of this act exempting a factory or the workers therein from the provisions of section 52, a worker is deprived of any of the weekly holidays for which provision is made in subsection 1 of that section, he shall be allowed, within the month in which the holidays were due to him or within the 2 months immediately following that month, compensatory holidays of equal number to the holidays so lost. 2. The state government may prescribe the manner in which the holidays for which provision is made in subsection 1 shall be allowed. 54. Daily Hours. Subject to the provisions of section 51, not adult worker shall be required or allowed to work in a factory for more than 9 hours in any day, provided that, subject to the previous approval of the chief inspector, the daily maximum specified in this section may be exceeded in order to facilitate the change of shifts. 55. Intervals for rest. 1. The periods of work of adult workers in a factory each day shall be so fixed that no period shall exceed 5 hours and that no worker shall work for more than 5 hours before he has had an interval for rest of at least half an hour. 2. The state government or, subject to the control of the state government, the chief inspector, may, by written order and for the reasons specified therein, exempt any factory from the provisions of subsection 1, so, however, that the total number of hours worked by a worker without an interval does not exceed 6. 56. Spread over. The periods of work of an adult worker in a factory shall be so arranged that inclusive of his intervals for rest under section 55, they shall not spread over more than 10.5 hours in any day, provided that the chief inspector may, for reasons to be specified in writing, increase the spread over up to 12 hours. 57. Night shifts. Where a worker in a factory works on a shift which extends beyond midnight. A. For the purposes of sections 52 and 53, a holiday for a whole day shall mean in his case a period of 24 consecutive hours beginning when his shift ends. B. The following day for him shall be deemed to be the period of 24 hours beginning when such shift ends, and the hours he has worked after midnight shall be counted in the previous day. 58. Prohibition of overlapping shifts. 1. Work shall not be carried on in any factory by means of system of shifts so arranged that more than one relay of workers is engaged in work of the same kind at the same time. 2. The state government or subject to the control of the state government, the chief inspector, may, by written order and for the reasons specified therein, exempt on such conditions as may be deemed expedient, any factory or class or description of factories or any department or section of a factory or any category or description of workers therein from the provisions of subsection 1. 59. Extra wages for overtime. 1. Where a worker works in a factory for more than 9 hours in any day or for more than 48 hours in any week, he shall, in respect of overtime work, be entitled to wages at the rate of twice his ordinary rate of wages. 2. For the purposes of subsection 1, ordinary rate of wages means the basic wages plus such allowances, including the cash equivalent of the advantage accruing through the concessional sale to workers of food, grains and other articles, as the worker is for the time being entitled to, but does not include a bonus and wages for overtime work. 3. Where any workers in a factory are paid on a piece rate basis, the time rate shall be deemed to be equivalent to the daily average of their full-time earnings for the days on which they actually worked on the same or identical job during the month immediately preceding the calendar month during which the overtime work was done, and such time rates shall be deemed to be ordinary rates of wages of those workers, provided that in the case of a worker who has not worked in the immediately preceding calendar month on the same or identical job, the time rate shall be deemed to be equivalent to the daily average of the earning of the worker for the days on which he actually worked in the week in which the overtime work was done. Explanation. For the purposes of this subsection, in computing the earnings for the days on which the worker actually worked, such allowances, including the cash equivalent of the advantage accruing through the concessional sale to workers of food, grains and other articles, as the worker is for the time being entitled to, shall be included, but any bonus or wages for overtime work payable in relation to the period with reference to which the earnings are being computed shall be excluded. 4. The cash equivalent of the advantage accruing through the concessional sale to a worker of food, grains and other articles shall be computed as often as may be prescribed on the basis of the maximum quantity of food, grains and other articles admissible to a standard family. 1. Subs. By Act 25 of 1954, S. 13, for subsection 4, W, E, F. 75 1954. 2. By S. 14, IBID. 455 and 56, W. Explanation 1. Standard family means a family consisting of the worker, his or her spouse and 2 children below the age of 14 years requiring in all 3 adult consumption units. Explanation 2. Adult consumption unit means the consumption unit of a male above the age of 14 years, and the consumption unit of a female above the age of 14 years and that of a child below the age of 14 years shall be calculated at the rates of 8 and 6 respectively of one adult consumption unit. 5. The state government may make rules prescribing a. The manner in which the cash equivalent of the advantage accruing through the concessional sale to a worker of food, grains and other articles shall be computed, and b. The registers that shall be maintained in a factory for the purpose of securing compliance with the provisions of this section.